Item number 1. Yes.
Yesterday I was placing for your lordship, my lord, this matter that where my application has been rejected on the ground that I have not given the pro forma within the time period. But I have, my lord,
So no reply was filed in the tribunal. Who is for the state? File a opposition. For filing opposition. Two. The next case is called his still. Yes. It was adjourned to enable you to make submissions. You have seen the last order.
Yes, sir. But, before that, my lord, this is a restoration application pending before you. My learned senior officer, the restoration to allow him. Allow him. Because there has been one. I was one on the earlier date when I appeared before your lordship. I prayed before your lordship that the delay should not be condoned in this particular matter. It is more than, my lord, 3 years.
Can is still pending.
Pending. Pending, that was the pending, and we have mentioned this matter before your lordship.
Any order has been passed on the can. We have mentioned doesn't mean anything.
No.
Then it is pending.
জানি হয়ে গেছে এটা pending.
Where is which can application?
Copy that has been served upon me, it says can number 1.
Can 1, can 2.
For restoration, can 1
Condonation.
তুই দিন এটা.
And this is one to this.
Oh.
Nine months. There is delay of 9 months. Two 56 days.
56 days.
Your
Page 4.
page 4. And when it was dismissed? 29/3/9.
March 2019. This application is filed my lord in December 2021. I know, sir. So it should be my lord,
21.
that because this is what my lord, my application, my lord, reveals, which is served upon me.
Huh?
The application which is served upon me, my lord, in the affidavit portion, my lord, it says December 2021. Because my lord, it is not, my lord, the case that I do have a bad case. This is why I'm taking this point, my lord. But the point, my lord, remains that the respondent before your lordship is an 86-year aged, my lord, widow who has been fighting for this pension since 1970.
So why you have stated 256 days?
Sir, actually, my lord, I am engaged in this matter. Initially, Sopon Banerjee was appeared in this matter, who was not in the panel earlier occasion.
We are asking you if you have filed
On
in.
the earlier occasion, my lord, I have stated everything before your lordship, my lord, but I could not understand why matter was not.
How you have stated 256 days? It is much, much more than 256 days. It's about 18 months. So why you have stated 256 days?
Paragraph 4 and 5. 256 days also. So, 29/03.
This application was filed on 10th of December 2021.
So nearly 3 years.
3 years.
2 years, 9 months or something. Anyway, there is no requirement of a condonation. There is no application of the Limitation Act. Point is, it is filed with delay.
Subject to correction of my lord, senior and your lordship, my lord, we do make a my lord, paragraph in the restoration application itself that we have done this delay, and this is why you do not file any section 5 application to us.
Yes, you are not required to file. Why you have filed a condonation?
No, my lord, actually, my lord, this is
But
my
see, if-
responsibility is a transfer receipt, my lord, that person was filed long back.
I can't understand what he says. Oh. What is the date of this information slip?
I have to take some instruction because
You will have to do something.
I kindly accommodate me to take some.
So can
I am newly engaged in that, I can, if the person concerned was not
Whatever it is
But I
not,
have to,
it
it
is
is
not
my
in,
responsibility, my lord, I shall take.
it is not in order. That's the point.
তপ্প করেনি, কিছুই করেনি।
And not this.
So can one condonation is not required. We'll allow you to file supplementary in can 2. Can 1 it can be disposed of as not press, not required. The learned
My- Recording of judgment of Rabia Vikani, there has been a subsequent judgment passed by the Honorable.
আচ্ছা, আমাকে কপিটা দিয়ে দেন না, একটা আমাকে দিয়ে দেন। I am asking for that judgment for last. Thank you. I am good.
Great.
First September আছে। Item number 3.
Lord, on the last order, my lord asked me to place on record by way of affidavit whatever I have relied upon.
The time.
Yes, sir. This is my supplementary affidavit.
What are those documents?
Documents, my lord said a bunch of rules, all these things. Whatever I have relied upon, I have given by way of supplementary affidavit. I have given a copy to my learned friend.
No, you are bringing on record further communications. Why?
Not communication. These are the related rules.
No, A6. Look at A6. What is A6? Why you are bringing these documents on record?
Minutes, my lord, these are the part of record. These are also part of records. My lord said whatever bunch I have given, I have given.
It was part of the record where?
In the read petition itself.
In the
read also it was there.
in the writ. This is the writ. What do you mean in the writ?
No, read petition in the trial court. It is a appeal, my lord.
It was on record before the Honorable Single Judge.
All these
These
things, my lord
documents were
said,
there.
my lord, that
My
this-
lord, I haven't had the occasion to peruse it. Therefore, my lord, if my lord can give me a short date, I'll come back after going through this.
I have not also got a copy from him.
I'm
Yeah.
just giving a copy, my lord.
We are not going to allow anything which was not there before the Honorable Single Judge.
No.
Rules, acts, of course, whatever you want to rely upon, but
Yes,
no
that
further.
is there. That is there. I have not made out any new case. No new case.
Now we are unable to proceed with this matter.
Lord,
for
no
some
new
reason.
case has been made out. As my lord has directed, I have given those copies. My lord said the whatever.
Why do you do it piecemeal? Why do you file cases like this? What is the fun in having 10 adjournments for nothing? We
My
don't
lord
know.
has asked me to do. I
We have
have.
asked you because you did not place it on record. What can we do?
I have replaced.
So if it is material before the writ court, you are not placing it, then what option we have then to ask you to place it on record? Why you need a request to place it on record?
Not on the last occasion, my argument is over. My last
Document is over without the documents which were forming part of the writ court records.
No, that is not there.
Then why you are filing this if this was already on record?
This is the rules and regulation.
No,
which are-
A6. Why you are filing A6?
It is a part of referred to in the writ petition.
In
That's
the writ
why
petition, but
Yes.
you did not file in the appeal.
appeal is a writ petition I have annexed.
You have
Yes.
annexed this.
Yes.
Then why you are filing again?
My lord said bunch of papers, whatever there, you file it in a supplementary.
No, we said whatever you have omitted, you file it. Not to reproduce the same thing again and again, just to increase the volume.
My lord, A6 was not referred to, which is why I was bringing it on record when my lord gave me the option of filing a supplementary affidavit on the last occasion.
No. If this has become impossible case somehow, we don't know what is the matter. So many cases every day we are doing this case, somehow we are unable to proceed further. Something or the other on every date. Now you are filing a bunch, this voluminous bunch, after making all your submissions.
Then-
We asked you whatever you have omitted, you place it on record. Now you are placing the same thing again. If it is already there, why are you placing it again? We don't know. It is at which page in the brief?
Because these are the bunch of papers, rules related to my lord required.
A6 is a rule.
No, the A6 is a document which
Then why you are filing that?
it was referred to in the writ petition. That's why it was not a crave leave was given. My lord considered it on the last occasion. That's why I have given. If lordship thinks it is not necessary, I can take back.
What do you mean we think? Who are
My lord,
we?
it will not go beyond the pleadings. It will serve your.
You are still completing the records. Just imagine.
No, my lord, I
Even
am
after hearing.
I am not completing any.
You
record.
are, because you did not place this on record earlier.
Yes.
Don't say no.
I have bunch have given rules. That rules have annexed. Nothing more,
So
nothing.
you
less.
keep saying the same thing again and again. Again, we will ask you why annexure 6. You will say annexure 6 is the record. Then you will say we are only annexing the rules.
Lord, if lordship considers it is not necessary, I will take back. No problem. But I have, for convenience purpose, I have given my lord. I have prepared an index. I have relied upon it. It will be helpful to my lord. Whatever I have done, lordship kindly sees it will be helpful to my lord, not even to my learned friend, because I have
So
prepared.
you have realized after arguments that it will also be helpful to us. We are very grateful.
It is not there, my lord. Index wise, I have prepared the rules I have referred.
Why you did not do it before the argument?
In argument, I have given, my lord. My lord has considered it. My lord has considered it.
Without giving them a copy.
Copy was given.
No. Thereafter we have
Bunch
allowed
was
you,
given to them.
only thereafter we allowed you the time to file it.
My lord, a bunch I have given to them.
Bunch you give them, we don't know what you are giving. This is not the way in a court proceeding.
That's why, my lord, I put it on affidavit. Whatever bunches I have given to him, I have put it on affidavit.
We
For
don't know what to
convenience
say.
sake, my lord.
It is becoming inconvenient. We are sorry to say.
Well, my lord, if your lordship doesn't take it, allow me to take it back. I am not submitting anything. Let him submit. For convenience parts, I prepared index wise, whatever.
This convenience, sir, you were required to consider
Lordship,
before
if
making the
your
submission.
lordship, my lord, considered it is not necessary, my lord, I will take it back.
Very good. You keep doing this. We'll never complete this matter.
No, let him submit. I have finished my argument. Let him submit. I have no part to submit. It is his part. On the last occasion, he was trying to. My lord said, "You whatever documents you relied, you put it on affidavit." Today,
That is because you did not place it on affidavit.
that is not the question. He requires some documents to be submitted for the sake of argument.
Correct. So
Yes.
you also said that you had some documents
No,
which
no,
you have
but
not relied.
I have relied upon the documents which are placed on record. My lord, seize my lord's order.
Yes.
I have placed the record whatever I have submitted. It is in the form of affidavit. By preparing index I have given so that it will be convenient to your lordship. Nothing more, nothing less. No new document I am coming. Seize the malak. I have prepared index wise.
We have to adjourn again. Very well.
May I please,
What
my
can
lord?
we do? We have to adjourn again.
But this is his document I have given today. If he wants to make any submission, I am here to. I want to also finish the matter.
It is becoming impossible.
May I
What can we
please-
say?
Let them submit me. I'm ready
We
to
can't
hear.
do anything in this matter. Yes.
My
I
lord,
have given him a copy,
Annexed
index,
to A-
nothing more, nothing less. A index has been
I
prepared.
have yet to come across any case where I have adjourned the matter so many times. On trivial issues
But
for nothing.
whatever limited capacity I have got, I have argued.
Yes.
I have heard it.
My lord, on the last occasion, when I started my submissions, I started by saying, tracing the history of the institute, which is when I was stopped because my learned friend said that I had not given him a copy of the certificate of incorporation, which in his affidavit, my lord, I see it at page 9 as Annexure A. The next thing that I referred to when I stopped, and has rightly been pointed by my lords, is Annexure A6, my lord. I started with the first Board of Governors meeting when I was stopped, and my lord gave me permission and liberty to file the supplementary affidavit. My lord, those are documents which I find in his affidavit, which were not referred to at the time of his argument, my lord. These are the two documents I see as of now.
Which two documents?
My lord, Annexure A
Yes.
and A6, my lord, which is the first meeting of the Board of Governors.
Yes, he has not read. That's why we asked him why he's filing A6.
Lord, because that is where I had stopped when my lords had given me liberty to file my supplementary affidavit. I had stopped at that point, my lord.
Keep filing, very good. What can we do?
My lord, and had I not been stopped on the last occasion, I would have completed my arguments, my lord.
It's becoming impossible. Actually,
Srilal Goenka, this is Jasjit Singh. This does not exist. My lord, a case that had been referred to by my learned friend.
I have given
Uh,
the copy to my lord.
My lord,
I have given the copy to my lord.
I was
Entire
unable.
copies I have given. Now he is not seeing, he is not finding out.
I'm unable
I have
to
given
find.
the copies of the same. Copies of the rulings I have referred to have been handed over to my lord. It is if he requires it, I can give it again. If he cannot find out, I have given the citation
My lord,
punch I have given,
used
my lord.
SCC online, and if I go by the name,
If he
it's a
cannot
probate
find out
case.
what I am to do,
If I go by the citation, my lord, it doesn't match, which is what I was just telling my learned friend.
আচ্ছা আমি দিয়ে দেবো, আমি এটা দিয়ে দেবো। I will give you. If you request a particular citation, I have made over to copies I have given to my lord. I have referred it to.
such a small issue of courtesy has to be resolved by the court.
Yes.
Such a trivial issue of courtesy, if for some reason somebody has not been able to take a note of the correct citation, it has to be an issue resolved by the court, that whether you will allow them to identify the citation or not.
I have opened my mouth. If he says, I am to say. Citation, I say, if it is not available to, I give you a copy. What more I can give? If he is not available from any citation, I intend to give him a copy.
That is all that you are required to say.
That I will give him. If he is not available from any site,
For anyone, you can also maybe in a case you may also make a wrong note. What will happen?
no, I have handed over copies. I have given the copies of the same. How it can be not? If I will give him a copy. If he requires a copy from that site,
Citation.
I am giving a copy just now.
Because it
Not required. I am giving a copy just now. If you don't have the copy.
If it is a citation, you need not give the copy.
I have given him.
You have to give at, you have to give only the citation.
According to me, he is not getting it from website. How he has searched, I don't know. I am giving a copy which I handed over to my lord.
So how do we resolve such a situation?
That I am giving, just now giving him.
Either you give a copy or you tally whether what they have noted has been correctly noted or not
There's
correct.
a wrong noting or I am giving a copy which I have handed over to my lord. I am just now giving him a copy. I have got a copy with me. I am handing over a copy, a particular copy on at least 7 or 8 judgments I have referred. If his one is not available to him, he is submitting to the court. I can supply him a copy. Just now I am supplying. If he
2004 Supreme Court 4377.
Where is the writ petition? Copy of the writ petition.
It has been in the paper book, my lord.
At which page?
So far as annexed at A6, my lord, it is appearing as one page 176. It is appearing on whatever document I placed on the last occasion, I have put it in a affidavit. I am not going anything beyond that. আমার
আমাকে যে সাইটেশন আপনি দিলেন
ঠিক আছে দিয়ে দিচ্ছি।
AIR 2004 স্যার আমি সেটাই তো বলছি কিন্তু আপনাকে বললাম ছবি থেকে সাথে লিখে নেবেন আমি লিখতে গেছি
A6 is already there in the paper book.
Yes.
Then why again you have given?
What I last occasion, a question cropped up regarding formation of the initial formation of the, before that it came as in deemed university status, it was a registered society, that's why this question came. My lord, he wanted to submit certain papers to substantiate it. On that score, my lord, I considered it, whatever related documents is with that, and whatever a bunch I have given, but in the first day, my lord put up this question. So what is, because it was initially under the Bardhaman University. Then it came as a deemed university status. From that, all the stuffs, because that's why we to help.
Annexure A6 already on the record. Why you have filed again? Again, we are asking.
This is to have a sequence of it, nothing more than.
So therefore, that is what we are saying.
That sequence, to create a sequence
What
of
sequence when it is already on record? Why you should bring it again?
My lord said, whatever documents you have relied upon, place it. I have placed it.
We said that you place all the documents again.
No,
Although it is on record, you place it again.
related documents, bunch I have given. If your lordship considers,
You
lordship
are
done
making it very difficult, sir. The same document you are giving twice.
I have given the entire minutes.
Yes, again for the third time, again you may give after the next hearing. Keep giving that.
2 pages were given the writ petition, I have given the entire minutes. That is
Very good.
That is nothing more.
Very good. You keep
I-
giving. Very good.
I have not given extra, my lord.
You have given extra. You are giving duplicate. Don't say you are not giving extra. This A6 has at page 176 come.
Yes, I have.
Then why you have given again?
Because it was only 2 pages.
Because only we want to give the entire document. So very good. For third time also you should give if you feel like it after 1 week. You think this helps anyway? That is why we are asking you. Giving the same document twice or thrice, what does it help? Please tell us. It adds to confusion or it in any way
Lord,
makes anything convenient?
To be candid to your lord, I had no intention to confuse your lordship. I wanted to help my lords in the administration of justice. A bunch was given in which a question came up. I have referred to.
Sir,
entire
what
thing
is
I
the
have given.
purpose? What is
Lord,
the
if lordship goes through it, it will help my lord.
what is the purpose of making a paper book? Tell us. It is for the convenience so that everyone knows the same paging is with everyone. The court proceedings can move smoothly. That document is already part of the paper book. Again, in this supplementary you are filing. How does it make anything more convenient? You tell us.
Lord, 2 pages are there. Question came up. I have given a bunch. I have prepared a index. That's why I have.
Very
given.
well, very well. If you are
If
adamant,
your lordship
you keep
thinks
giving.
that it is not necessary, I can.
No,
take
why
it.
should we? You keep giving as many
Lord,
documents.
I have not given anything extra.
Very well.
It will serve.
Bunch of documents have been filed by both parties.
আপনি 2004 দিয়েছিলেন সেপ্টেম্বর।
Item number 5.
Your Lordship, I am appearing for the respondent. On the last occasion, Your Lordship has been pleased to direct us to reaffirm the affidavit in opposition and to file as because it was not available in the record of Your Lordship, my lord. My lord, I have done, my lord, the same affidavit in opposition. My lord, I have reaffirmed. My lord, may I file?
Yes. Earlier it was not filed.
No, not in the record, though affirmed but not filed. Your Lordship has been kind enough to give me that.
Where is the petitioner? Have you served a copy on the
No,
petition?
I will serve, my lord. He was not available on the last occasion, I think. I will serve, my lord. Your Lordship kindly
Take it.
fix it and direct the petitioner to, my lord, file affidavit.
He is not here.
No,
for-
that's true, my lord. Your Lordship can pass an order, my lord, giving him a time duration. I will communicate the order along with the copy of the affidavit in opposition.
You know the learned counsel who is appearing. Are you aware who is appearing?
আগের দিনে appear করেন?
Because it is a rate of 2010. Therefore, we are asking. We don't know who is appearing now. Last day also there was perhaps
Yes, yes.
nobody was appearing.
my lord. He can also send a communication to the client also, the petitioner, if your lordship directs.
See, there is an advocate's name appearing in an earlier order. Mr. Dipankar Das Gupta.
My lord, I will find, my lord. I will find, my lord.
If you can locate him, it
Yes,
will be
at the
better.
time of recess, I will collect the mobile number.
Mr. Dipankar Das Gupta and Mr. Malay Kumar Chakrabarti.
Very well, my lord. I will
Two
collect.
persons. You have a look at the records
Yes.
after the case is over and you try.
Yes,
Yes.
I will complete it.
An affidavit in opposition.
Six. Item number 6. Item number 6. Seven.
Lordship, I am appearing for
I am
this
appearing on behalf of the petitioner.
Yes.
The petitioner, my lord, is being in the examination of LDC. The post has been declared. Thereafter, sit in the examination. But in the examination, there is a condition that appeared in the notification as well as admit card, as well as, my lord, in the question paper also. That question number 1 should be answered in English. Question number 2 and 3 be answered either in English or in Hindi. That is entire paper.
Question number 1 be answered.
Question number 1 no. Paper number 1 should be answered in English. That is mandate. And question number paper number 2 and 3 should be answered in either in English or in Hindi, in whole,
This
as a whole,
was stated in the advertisement itself.
and as well as admit card also, and the question paper also that
All right.
appear. But here, one person who stood second, he answered second paper, answered Hindi and English. One question answered in English and another question answered in Hindi. That dispute has been arose, my lord. Thereafter, the matter appeared before the Honorable Acting Chief Justice Nishita Matte as her lordship.
So
became
how
one.
are you agreed by that?
Yes,
First tell
Lord,
us.
If the paper has been cancelled, paper 2 and paper 3, then he should be, his name should be out. Therefore, those who placed in the third, he will come to the second, and those who placed in the fourth, he come to the third, and those who like that.
So therefore, again, we are asking you, how
Yes.
will that benefit you?
I was placed in fourth.
Fourth. And how many vacancies were there?
Vacancy 2, thereafter, one vacancy has been arose due to lien by the telecom department. Due to lien, one vacancy has been arose. Therefore,
To
the
lien a vacancy as a reason. How?
lien, in the lien, the telecom department take one person from the Geological Survey of India. He has been absorbed there.
After appointment.
Yes, my lord.
After appointment as LDC.
He has been absorbed there.
No, not correct, not correct.
He has been absorbed there. Thereafter, those who got
Please,
yes,
it is better that what you are saying we should understand also. So you said that you are at serial number 4.
yes,
If this person at number 2,
yes,
he goes, then you come to serial number 3.
3.
So even then you will not get the appointment.
No, 3 has been
So
provided
3
appointment.
3 was also appointed.
Yes, 3 was also appointed.
Then
If I come to place in 3, then I should be appointed. According to merit list, I am in 4th.
yes.
If second person, who stood second, he has been out. Then who stood third, he will come to place second.
Yes. So there are
And
only 2
those who, in the notification, there are 2 vacancies.
Yes. Then
Thereafter, my lord, the telecom department,
that was not an advertised vacancy.
no, that is not advertised vacancy.
All right. So we are clear. Now please proceed.
So telecom department took
Everyday
lien
vacancy.
one person,
All
third person, those who
we
got
have
third,
understood. Yes.
those who placed in third,
Yes.
he has been provided appointment.
Yes.
So if those who placed in third, he has been provided appointment, then I should place in the third, I should provide an appointment.
How you can? There are only 2 vacancies. Then how you can be appointed?
No, how the third has been provided?
Third has provided because there were 2 vacancies.
No, there are 2, but 1 and 2 has been provided.
Oh. And third has also been appointed.
Third has also been provided.
One more vacancy may have occurred during the process.
Why the third has been provided?
Yes.
That from GSI, the telecom department took person as a lien. Finally, there has been they has been absorbed there. So
All right.
therefore,
So all right. Let us see. Well, now proceed. What is it? Tell us.
then my question is, if
Yes.
the second person is out,
Yes.
then I came to the position of third.
All right.
If the third man is appointed, then I should be appointed.
Yes.
You make
All right. All right.
You make grievance.
Where is the advertisement? Show us the advertisement.
Advertisement. That is page 50. Circular on 14th July 2010. Page 51, my lord, the vacancy shows in page 51.
unreserved post.
একে পেয়েছি ফার্স্ট কে সন্তোষ সেকেন্ড হচ্ছে নবীন
Your Lordship, kindly see the condition. Condition number one.
দাঁড়ান
It wanted to be the candidates who have the option to answer paper 2 and 3 in Hindi or in English. Paper 1 will have to be answered in English only. The option will be for a complete paper, not for a different questions in the same paper.
So the third person, he has also answered like that.
Third person has been answered like that,
He has done it according to the,
according to the condition. He has answered. But the second person in paper 2,
already you have said that. You have said that. We have heard that. Yes. Need not repeat.
Page 57 is the marks, your lordship, which admittedly shows that the petitioner secured lower marks than the last selected candidates. That is first and second. Page 57, if your lordship kindly comes. My lord, serial number, এটা দয়া করে এখানে রাখো হাতে করে। Serial number 4, my lord, is Naveen Singh, who the petitioner is challenging, who has answered, my lord, both Hindi and English. It is not that he has answered wrong answers. It is only the case is that there is either English or English, Hindi. Naveen Singh has written both the ways. And answer is correct. He has secured, your lordship, 157, serial number 4.
He is the first impanel candidate
He is the second panel candidate,
at serial number 4.
serial number 4. I'm grateful.
Who is the first impanel?
First,
serial number 5.
first is serial number 5. My lord, his name is Santosh Kumar Thakur.
He got 330.
Kindly see. And
And
Is the
বলেন,
petitioner.
বলে দিচ্ছি দাদা, বলে
and the person at serial number 4.
6 is the petitioner.
4 is what is the name of the person at serial number 4?
serial number 4.
Is Naveen Singh.
Naveen Singh, who is challenging.
He is the person who has used both
Yes,
languages.
both the. Now, at any stage of imagination, my lord, if for the sake of argument, though not admitting, if he goes out from the zone of consideration, then also has failed from your lordship, the petitioner cannot come because 2 posts are there, then third will come. And he has not made party to the third candidate in the writ petition.
Who is the third person in this result?
Yes.
Serial number
Third.
14. Serial number 14 is the third person.
Third,
He got 301.
no.
Serial number 14.
Is there any dispute on this aspect?
বলুন, দশের
There is no dispute. Regarding third person, there is no dispute.
Who is at the third position?
Yes. কি নাম? কত নম্বর? 14. Serial number 14, সজল কুমার চক্রবর্তী।
Sajal Chakraborty.
সজল কুমার চক্রবর্তী। Serial number 14.
Now, please tell us the total marks of this serial 5 is having a total of how much marks?
Serial 5 is first one. He stood first.
Total marks কত? First. My lord, first is 330.
Yes, serial number 5.
Serial number 4?
4 is second.
কত পেয়েছে? 329. 4 is
And serial number 14?
14.
301.
301.
And where is the petitioner in this list?
299.
299.
Where is he? Which serial?
Serial number 6.
He has got 299.
Yes.
99.
So in between the petitioner and
Third one.
Sajal, there is nobody.
Nobody. And so far, the lien part which has been argued, my lord, he has not made even a party to that, and that is not connected with this
Let my
advertisement.
learned friend
Not
say
connected
that,
with this advertisement.
let my
So-
learned friend say that serial number 14 has been in lien. He has been joined
Sir,
in
you
the
have not
telecom
made
department.
party to the
Please,
14, so the
please,
question
please.
will not arise.
Let
So-
him complete, then we'll hear.
Yes, let him complete.
So 51 is the advertisement. It says only two posts.
Yes, two posts.
There are two posts, no doubt about it.
And he is challenging, my lord, the answer scripts of serial number 4, that is Naveen Singh. That is who secured 329 and who had answered.
Yes.
paper
So
12.
how this third person, according to you, has been appointed?
Third
What-
person has been appointed.
What is your case?
He has been appointed.
Where? Show us in your OA where you have said. Show us from your OA where you.
I came to know from my client.
Show us from your OA what you have said.
I have not annexed anything.
In your OA what you have said.
See, subsequently I came to know that 301.
After the OA was over. So you did not know before the tribunal that he was appointed.
For the tribunal, I did not know that 301 has been provided. Thereafter, I came to know that 301 has been provided appointment due
Yes.
to lien.
Where is that statement in the writ petition? Show us.
This petition after completion by the tribunal. Thereafter, I came to know.
So where you have stated in the writ petition, therefore we are asking.
Writ petition, thereafter, the writ petition has been filed.
Admitted.
Admittedly, thereafter, writ petition has been filed. The third person, it is my learned friend show. My
Please, we are-
say that
We have,
30 has
please,
been
res-
provided or not.
please respond. He will respond only if you have made an assertion that he has been appointed. Where you have stated that this person,
I have stated that he has been appointed.
neither before the tribunal nor before the writ court. Then we are not going to ask him anything about this third person. Then we are not going to ask him.
Person has been provided.
We don't know. Either you show from the pleading or we are not going to. We are very clear. Therefore, we are asking you, show us.
I have not said.
Then we are not going to ask him about this third person. Sorry. There is no scope. If you have made out a case, then only we will ask him. Otherwise, why we should ask?
I made out a case in connection with the second person.
All that we have understood. That we have understood. But even if he goes, that will not help.
Lordship, kindly see me, Lord, page 71,
Yes.
4.
Yes.
71 is a paper 2. In connection with the second person,
Yes.
paper 2, he answered one question number 3, in English.
Yes.
Then your Lordship kindly turn to page 74.
Yes.
He answered in Hindi.
They are not disputing, they are accepted. Respondent has accepted that he has used this language. But they say because in the question paper it was mentioned. This at
Therefore,
51. See what they have said, page 51. Here. Right in. But in the question paper, they say it was not discussed.
Is a question paper is there on record?
I have the paper.
No, is it there on record? He has obtained this information under RTI.
Yes, yes.
So where is that?
from RTI, I have got the answer script.
Your lordship want to see the paper?
No,
of the-
we have got it, page 70.
Yes.
Sorry.
71.
Clause 3.
This is missing. This is missing. Complete. Do not. Then says are correct. Just note that he should be excluded because he has used this language. And from his exclusion, he will get no, no, sorry, we are not going to that
My lord, may I submit only one thing?
Yes.
My lord, if your lordship kindly takes the trouble to look into page 71, it has been written either in English or Hindi. My lord,
No, at page 70, it has been written in clause 3.
yes, that's true.
Yes.
That's true.
We have already
Yes,
seen that.
answers have to be written. either
See,
in
what has happened, what appears to have happened is at page 51,
Yes.
it is specified that for complete paper it has to be done. But in the question paper, this clause is missing.
Yes,
So apparently he has used both language.
yes,
Now it is nobody's case that the answers are wrong.
yes.
But
I'm
they
getting-
say that he was not allowed to write in both language.
Yes.
But that is not going to help him.
Also.
It will be
also
even if his candidature is set aside, he will not get anything
No, nothing.
because he has not made out any case either in the OA or in the writ petition.
Then,
There-
my lord, certainly your lordship's thinking, I understand.
Yes.
Because the post is true, if he has been turned down from the post of second position, then the third will provide. That is your lordship's,
And third has not come forward with any grievance.
third is not come forward.
So what is
But my allegation is against second.
that we have understood? Your allegation we have understood. He could not use two languages to complete the paper. That is your
That is in the instruction as well as admit card and the question paper also.
no, not in the question paper.
Question paper has been
See clause 3 of the question paper. Read clause
70.
yes, read clause 3. It does not say you read, there is a difference. In the advertisement, it
Either in English or
or in Hindi. Yes. In 51, it says complete paper in Hindi or English.
complete paper.
So here that is the
Cannot be segregated that.
yes, that's all.
That's all.
Heard learned advocate for their
Item number 8.
But I am for the respondent in this matter.
Item number 8, learned ASG is appearing, Lordship. He has not come to the court due to his medical health, Lordship. Kindly fix the matter next week, if possible. Kindly fix the matter next week, Lordship, if possible, Lordship. Due to his health reasons, he has come.
So this is the matter.
Next week, there is an interim order till 22nd.
Yes, ma'am.
When do you want it?
Lordship, next week, Lordship, anytime.
Next week, it may not be possible for us.
It is that matter. The order of this tribunal affirmed by the Appeal Honorable Supreme Court in respect of one Siddiqui case. And Siddiqui is the list in the promotional list. He has got the benefit.
There is an interim order, so therefore,
That is the
since it is on the ground of medical ground, therefore, we are informed that the learned ASG
Item number 9.
हाँ उसके बाद CPNs. Where are the recruitment rules? You are filing opposition. Copy has been served. Reply also filed. Then why you are filing now? No. Opposition is taken on record.
To the Public Service Commission, because my lord, what I relied upon.
Have you seen the last order?
My lord,
Have you seen the last order? Yes, recruitment rules and advertisement. We have dictated the order in court. Yes,
I am handing over.
yes. Both are there.
No,
But
this
I
is
meant
the
in case of-
advertisement, my lord. Recruitment rules, my lord, whatever I have found, my lord, from the. My lord, I am handing.
This is appointment to which post?
Sub officer, my lord, in Fire Services Department.
Sub officer
Sub officer.
in fire department.
Part. recruitment.
What is your degree?
But my degree, I am a mechanical engineer, but I am producing a BTech degree.
Hmm?
BTech,
BTech.
my lord, yes. It has, the diploma holder is in fact in the recruitment rules itself. And in the advertisement, my lord, it's a science graduate or it's
Will be guided by primarily the advertisement because that is the thing in response to which.
whatever I have found out, I am submitting it.
Yes. So the requirement in advertisement is
Science graduate or it's science graduate with physics, chemistry, mathematics or it's I did my degree, my lord, through lateral entry. My lord, goes
through
lateral entry, my lord, government of West Bengal Higher Education Department, my lord, has my lord, that those who are diploma holder, they do a common entrance test. Entrance test lateral.
holding what diploma?
Yes, I got diploma, my lord.
Which diploma of what? What diploma?
My lord, from a technical institution, my lord.
ITI.
Yeah, my lord, 3 years course. I completed. I was having my lord, chemistry and mathematics. And as also, my lord, when I was, I joined my lord.
So what is your case? ITI is equivalent to graduation.
Thereafter, I completed my mechanical. There also, my lord, physics was there. My contention is that physics, chemistry, mathematics was in the diploma and lateral entry has been recognized by the university because I have got the degree from West Bengal University of Technology. My lord, then BTech is equivalent to a graduate. BTech is a graduate.
So BTech is a graduate. That is your case.
Yes, BTech is a graduate.
Yes.
And I am having the qualifications, my lord, and my lord, the combinations were there that I shall take my lords. Here. What was the combination? What are the marks? What was the examination? The results I had, those my lord, India results I had.
BTech is a graduate because BTech includes physics.
BTech includes fields. Because my lord, when GTech I was admitted, but only first year's concession was obtained. It's a 4 years degree regular degree. And I was allowed to be admitted in second year. Having regard to my diploma, my lord, where I have already completed in the last 3 years.
Yes.
I tried for but the written test was held. I successfully came out.
It was a 2-tier exam or 3-tier exam? How many stages? Recruitment is in how many stages? 3 stages. Written?
Written, endurance test, and interview.
So you have qualified in all?
I have qualified, my lord, only during the interview I was denied on the sole ground that a BTech degree is not equivalent to a degree having science, physics, chemistry, and mathematics.
This reason was assigned by the interview.
Was assigned as it yes, my lord, from the affidavit. My lord, the celebrity.
So only those who qualified endurance, they will go to the interview.
Context, my lord, about the Calcutta University's case.
About?
Calcutta University's case, my lord, 76-1. When I applied for, I have disclosed all my documents and everything. And only after that, I was allowed to sit for the written test.
On grounds of equity.
Also, because since those 2 steps have gone, and according to me, the responding authorities, I itself at the stage of interview, they have used.
So everyone who has cleared the endurance, they have to be allowed to in the interview.
Yes, madam. After the written test, those who have completed written test, endurance test, they were called on for interview. They were called on for interview. I was also called on for interview. But I.
Oh, so you are claiming that equity has accrued in your favor and therefore it cannot now, you cannot be divested of whatever benefit has been accrued in your favor. But the benefit has accrued only up to endurance. You were never cleared to declared to have cleared the interview.
No, I was not allowed to appear at the interview.
Oh, all right.
I was not allowed.
So you did not participate in the interview. You were prevented.
Yes, I was prevented. That is the reason, and that's why, my lord, initially, my lord, a repetition was moved on the ground of repetition, my lord. The court said that I have to move before the West Bengal Administrative Tribunal.
Did they give you any written reason why they are not allowing you? No. And what was the date of interview?
My lord, 29th of April, no, 28th of April, 2027.
28 for
8th of April, 2027.
27.
No.
Yeah,
The
my lord,
written test was 29th
sorry.
April 2017.
yes, 2017, not 27.
29th April 2017.
For
That date is correct.
written exemption.
83.
The Lordship will kindly come to page 5. I have stated the interview was scheduled to be held on 28th March 2018 and was being issued administered for that purpose. But on the day of the interview, surprisingly, he was not allowed to appear at the interview. Page 5, I have stated, my lord, paragraph 5, page 5 of my writ petition.
28/9/2018. Yes, this is written by the candidate himself.
Oh, he was compelled to write that letter.
No, sir.
That I have stated, my lord. Yes. Acha, ke bolbe.
No, we are on the date. Give us the correct date.
Yes, date is 28th of March 2018. At page 5, my lord, will get.
Then why you have written in your communication 28/9/18?
Page 83, can you see page 83?
Huh?
Can you see page 83?
That is what she has pointed out. So we are asking him. That is also the petitioner's version.
And 1 year diploma.
That will come to later. Let him make his.
My diploma. My diploma in 1 year.
My lord, date, my lord, 28th of March 2018.
From where you are getting this date? You told us 29/4/17. In this application written by you, it is 28/9/18. Now you are giving us a third date.
Was my mistake. Was my mistake. Your lordship will kindly come to page 76.
'83 appears to be wrong. Page 70. 83 appears to be wrong because the letter is of 22/4/18 and it is referring to 28/9/18. How it can be? It's a futuristic date.
Your lordship will kindly come to page 76. You are requested to appear for an interview before the commission at 11 a.m. on Wednesday, 28th of March.
28/3/18. That appears to be correct. So 28/3/18 you appeared for the interview. You were not allowed to appear.
I was not allowed, and then I was asked to write that if you write such a letter, then we can consider. My lord, under coercion this was done. Now, my lord,
He has done, he has stated, he has written to them. You have said that you will reply within 15
State, our team.
No, sure. You have just said reply within 15 minutes.
he একটা application হবে। বলছি, তুমি ওয়ানের হয়ে affidavit দিলে কি করে তাহলে?
Why they are quarreling amongst themselves?
Respondent number one to state.
No.
When did you move the tribunal?
Tribunal, my lord, after, my lord, and on the ground of jurisdiction.
Where is that order? Order passed in the writ petition?
Page 84. Can you see page 84? Then 18.
Yes.
Learned tribunal, after being prima facie satisfied, was pleased to keep one post vacant. All along it was. And I mean, even when I moved before this honorable court, my lord, subsequently the other bench, my lord, after being satisfied that an injunction was there, it was granted. Now, the surprising thing is, my lord, on the day of the final decision by the West Bengal Administrative Tribunal, though I appeared, I submitted the argument over there. Well, it has been recorded none appears. None of my submissions were, my lord, considered by the tribunal. That, my lord, we find from page 121. Judgment, my lord, it started from page 122. Fully, my lord, on the basis of the submission of the respondents, my lord, the original application was.
If that has wrongly been recorded, this is not the forum. If that has wrongly been recorded by the tribunal, this is not the forum. Hmm?
My lord, tribunal has wrongly recorded, my lord.
Then what is the forum? You tell us in law.
Challenge, my lord, not only on that ground.
All right. So therefore, let us see what is there on merits. Tell us.
Now, your lordship kindly come to.
And what do you have to say about your application? Page 83, which was annexed by you before the tribunal.
This application, my lord, I have submitted, my lord, that this application was in fact under compulsion and coercion.
Where have you said in your OA that your course included the chemistry? To us.
Page 40.
40.
Petitioner submits that in a 4 years bachelor physics, chemistry and mathematics remains there in the first year. Case will be diploma course with the combination of physics, chemistry and mathematics, and as such, are no ground whatsoever.
So you were not admitted in first year. Therefore,
I have not admitted because my lord, through delay.
all right.
Because it's my lord, government of West Bengal higher education.
We have
Department.
understood. So there is no there is no incoherence between this statement and page 83. It remains the same. That there was no chemistry in the BTech.
My lord, you also.
Oh yes, yes. Please read again. Before you say no, please read again.
My lord,
Yes.
my lord, may I explain?
Yes. You may. That's why we asked you to explain. Yes.
Whenever, my lord, this degree.
We have understood what you have said. It is in so many words. You say prior to this, I have studied this in the diploma. Therefore, there is no question of no chemistry. In your written submission, you say that I have answered the question in chemistry also. Therefore, this cannot be a ground.
My lord, you will also kindly appreciate.
Both things have to be seen together.
You will also kindly appreciate.
Yes.
Because in 3 years diploma course, physics, chemistry, mathematics was there.
There. That you have said. Yes.
And my lord, that.
But not in the BTech.
No, I'm coming. In
Yes. No, there is no statement.
physics was there.
Show us the state. We are asking you chemistry. We are not asking about physics. We are asking you chemistry.
May I complete my submission?
Yes.
Here, my lord, the consideration through entrance examination, joint entrance lateral examination, my lord, the consideration was that for that 3 years diploma course, they will be granted a benefit to be admitted in second. Taking into account that year, but that I have a disclosure how it has been done by the government of West Bengal Higher Education Department, it has done so. On that basis, my lord, I have I took the I appeared at the GLET examination, and thereafter I got admitted after being successful. So, my lord, if that degree is not integrated, you will also be trying to see the degrees given to. Start from the marks and all these things from page, my lord, 57. Page 57 onwards. One chemistry, one mathematics. Then the next field, chemistry, 2 engineering mathematics. Then physics lab, chemistry lab.
These are mark sheets for which exam? Which course?
From the
Diploma course.
Yes. The theme alerts of all semester results I have disclosed in diploma.
Yes.
All are up to page, my lord, diploma course, my lord, page 60. Awarding of diploma. And my lord, then I got registration, my lord, in BTech. In the lateral entry, you will also can come to page 64.
$64.
Admitted under lateral scheme. The moment I was allowed to be admitted in second year, it means, my lord, the BTech degree becomes an integrated one, including those qualifications obtained during diploma. Next page, my lord, you will also kindly come to page 65. So that lab was there in the safeguard, it was appear, my lord.
We are not asking you about physics. We are not interested whether physics was there or not. We are only interested to see whether chemistry is there.
Was here, but otherwise,
We have understood what you are saying. You say, I have studied chemistry in diploma. Taking that into consideration, I have been allowed a lateral entry. Therefore, they cannot say that I have not studied chemistry. This is what you are trying to say.
I'm trying to. My lord, it is now not open with the authority, my lord, at the time of interview to deny. My lord may kindly remember the principles laid down, my lord, in Calcutta University.
Correct. We said we have understood you are relying on equity. Equity has accrued in your favor.
May I read for my satisfaction at least, judgment.
Kurukshetra University is on equity.
What the language has been used, my lord, that I wanted to submit.
Oh, the judgment is there.
Yes. Yes.
Yes.
Yeah, the subject matter was that initially an appointment was, an admission was given.
No.
But he was allowed to appear at the exam. Subsequently, the university sought to declare him ineligible. At that stage, my lord, the case was initiated. Now that your lordship can become eligibility. Come to my lord, paragraph 6 at page 136. I am reading, my lord. Right, my lord, the first paragraph, my lord, first part of the statute clearly shows university to withdraw the certificate if the applicant has failed to attend the prescribed course of lectures. But skipping that, but this could be done only before examination. It is therefore manifest that once applicant was allowed to take the examination rightly or wrong, then the statute which empowers the university to withdraw the candidature of the applicant has worked itself out, and the applicant cannot be refused admission subsequently for any infirmity which should have been looked into before giving the applicant permission to apply. My lord, in paragraph 7, my lord, there was ample time and opportunity for the university authorities to have found out the effect. In the circumstances, therefore, if the university authorities excuse the infirmities which the admission form contained and allowed the applicant to apply part 1 examination of April 1972, then by force of the university statute, the university had power to. Next. My I think elaboration, let me place paragraph 9, my lord, after skipping my lord, first 4 lines. Starts from my lord, this letter obviously written because the applicant was very anxious to appear at the part 2 examination. This is similar to that my lord, which I was compelled to write. Part 2 examination, and the letter was written and the complete ignorance of his legal right. The applicant did not know that there was any provision in the statute which required that he should obtain permission of his superior officers. Lastly, my lord, according to my lord, the appeal was allowed to student was allowed to examination. Here also, your lordship can see the authority when the application form was filled up. My lord, all the documents were disclosed. Everything was with the authority. So, my lord, authority, after consideration, my lord, issued the admit card to appear at the written test. Then again, further time was there. I was issued an admit card for endurance test.
All this you have submitted.
Yes.
Already you have submitted this. Yes.
Whether at this stage, my lord.
That also you have submitted. So both points you have completed. One is that the chemistry in diploma cannot be ignored. The other is on the other end of the spectrum, that even if there is a deficiency, there is no scope now to highlight it. Both these things. Yes. Where is Mr. Mukherjee?
Will you kindly see the advertisement. Page 72. Although it is in Bengali,
72.
in Bengali, but just 78. Qualification. Degree from a recognized university with physics, chemistry, and biology.
You are referring to page 73.
72. 72.
72 is not in English. How you are reading?
No, but just sum and substance.
Please.
Sum and
You please. Please.
And sum and substance that he must have a graduation degree in physics, chemistry, and
See, what he is saying is he is not claiming that he has a graduate degree. He says your state government has a system which recognizes diploma as equivalent to first year of BTech. So first year of BTech, if he was otherwise required to do, he would have studied chemistry. Your government recognizes the diploma as equivalent to first year. That means chemistry is included. It becomes a composite. So how you can say that he has not studied chemistry? That is what he said.
but lateral entry.
Yes.
But then out of 3 years course, but he has not studied first year course.
That's what he's saying, because the system recognizes the diploma as equivalent to first year. Substantially, that is his submission.
Sure.
Yes.
But if the notification or issued by the PSC, he must be a graduate or equivalent with
Yes.
physics, chemistry, and biology. He got diploma in a particular subject in a lateral entry. Lateral entry, that means first year course is not to go.
No, the BTech is not a diploma.
But because of lateral entry, he did a BTech. He got admission in a BTech, but in a lateral entry, not direct. If he was a direct admission at the first year, then physics, chemistry, biology would be there. But in the graduation level, he don't have a chemistry as one of the subject. And Kurukshetra University case is not applicable here.
What is not applicable?
Kurukshetra University.
We have asked you a particular question on this issue.
Yes.
Kurukshetra University, we will deal with it. Don't worry. We will allow you to make your submission also on that.
And kindly see.
But this is a point which he has raised. We are giving you an opportunity to make your case on this basis.
Yes.
Is it your case that the BTech which they hold is inferior to other BTech?
He cannot say that I have got chemistry in the BTech.
Therefore, is it your case that his BTech is inferior to the other BTech?
No.
Cannot be.
No.
Both are BTech.
No.
The BTech first year, which includes chemistry, you have exempted because you rely upon chemistry he studied in the diploma.
But
then
he does not have a degree in chemistry.
So therefore, there is two kinds of BTech degree.
Yes.
There is two kinds of BTech degree.
Two kinds of lateral entry and direct entry.
No, that is not the point. The point is BTech degree is one and the same.
BTech degrees are one and same. But particular this type of job, staff officer of the fire services. Why this and that? Can you see the what of the regulation? He must have a knowledge in swimming and other such things. And health is height must be 5 feet 6 inches, and 32 inches in the chest. All these figures were there. But as soon as that he was called for written test, he is successful, but he could not be allowed to interview because this defect was detected at the time of checking verification.
Where have you stated why he was prevented? Where is the reason assigned?
Kindly check in the reply before the tribunal. On page 77 for a moment. 28 March. there for interview for the post of sub-officer under the Department of Fire and Emergency Services, advertisement number 15 of 2016.
You are reading which page?
Page 77.
77.
Yes, written by the petitioner.
No, we are asking you, where is the reason assigned by you?
Yes.
Where have you assigned the reason why he has not been considered?
Kindly see that. A reply before the tribunal. On a page 87, paragraph 5. This is the reply by the PSC. Reply only by the Public Service Commission. Paragraph 4 and 5. At the outset, I submit that the instant application is misconceived as not maintainable in view of the fact applicant has applied for the post of sub-officer in Fire and Emergency Services, advertised by the Public Service Commission through employment notification number such and such. In the said advertisement, one of the main eligibility criteria was mentioned the science graduate from recognized university of physics, chemistry, and mathematics. Applicant has invited to appear in the interview as an eligible candidate who belongs to SC category with other eligible candidates to judge their suitability to the post. But before the interview, he was found ineligible after checking the mark sheets of BTech found produced by him. It is found the subject chemistry was mentioned in the eligibility criteria. The said subject was not incorporated in the BTech thesis of the applicant. Hence, he was declared ineligible for the such. Then I state that the applicant wrote a letter to the Secretary for Public Service Commission in which himself admitted and wrote that chemistry was not in his subject in bachelor degree. Later is annexed 52. Thereafter, the applicant filed instant appeal which is evident that verification is granted as such. Not say that, but this is the ground technique.
So one person who has got into a BTech directly, he will be allowed.
Yeah, because he will undergo the chemistry in a first year course, 100 marks.
And this BTech is being given by which? The state universities.
University of Technology. Huh? Huh?
So both are having the same degree, but one will be eligible, one will be not eligible.
Now, if he got BTech degree in a direct admission with a chemistry physics,
Where is the scheme of this lateral entry?
that has not been annexed. That is a act, a separate 2013 act is.
We would like to see what is the scope, and object of this lateral entry.
That will be from the respondent number 4, Maulana Abdul Kalam and Azad University of Technology.
Because it appears from your stand that BTech, how it can be that one person having a BTech degree will be allowed and the other not allowed merely because the admission mode is different. So can you give a BTech degrees to someone who does not complete the course required for BTech? You cannot. UGC and the National Technical Education Board will not permit you.
No.
So you have to ensure that they have completed all the requirements which is mandatory for a BTech.
But this university is recognized and approved by the AITC.
Therefore, we are saying AITC will not allow you. All India Technical Education will not allow you to give a degree unless he qualifies and completes all the requirements of a BTech. So therefore, BTech degree, one will have different value and the other will have a different value.
Where the BTech is the only qualification. without mentioning any
So
subject.
where is this concept? We want to see what is this concept?
Oh, so that would be
Whether there is it, we don't know. Whether your scheme, it contemplates that it will suffer from certain disadvantages or it doesn't, we don't know. We want to see. Otherwise, the prima facie, it appears that plus you give us a translated copy of the advertisement also. I am not able to understand. My brother can understand. Translated copy.
Office memorandum, my lord, regarding this advertisement.
just postpone.
Acha, yes.
I have fixed my lord regarding benefit of my lord that AICT and all other things in my reply. I have annexed my lord.
You have given in your reply. So they are required to see. Therefore, we are asking them.
Was not upon my lord. Yes, I have served upon it. State has not instructed me. Anyway, either in the tribunal or
So this is primarily to be responded by the state because this concept is theirs. They are only accepting the degree as per the whatever is the requisition sent to them, that requisition must be specifying the qualification and everything, and they will go by that. So how the state can justify that two persons having the same degree will be treated differently? That what we want to see.
Lateral entry and but
Yes, whatever entry, you cannot say that one is having a lesser BTech degree than the other. Can you say AITC will allow you?
no, AITC must be recognized that syllabus and pay scale will be, they will be
Therefore,
prescribe the syllabus, they will prescribe the pay scale.
both the
and
degrees,
teaching
whether
staff.
both the degrees are mandatorily required to be considered equivalent, or there can be a distinction between the two BTech degree based on the source of admission. Whether the state can consider the two degrees to be different only because the manner and source of admission. But yes. But thing is, one who has come through lateral entry is also having BT. Yes.
I don't know. 2016 selection process, 2017, 18, 2025. Only 51 post was there. Was that
One post has been kept vacant. Under which order? There is a direction. Where is that direction? Yes, there is a direction. You please enlighten us on this issue. The submissions advanced on behalf of the We have any matter at 2 p.m. 27th, we have any matter at 2 p.m. No. 27th, 2 p.m.
By giving a copy.
Giving him,
The documents disclosed regarding the scheme.
you take this back, you can place it on the next date if required. This one, I have scribbled on it, so it has to be on there. Item number 10.
Should I appear on behalf of the affidavit in opposition, Your Lordship? I shall serve a copy to my learner.
You will have to go through.
Ultimately, on the end of.
No, you can proceed if you want, we will proceed. If you don't want to file reply. All right. Affidavit in opposition is taken.
Opposition in the tribunal, they cannot say anything extra what they have said. That is a part of the.
Affidavit in opposition is taken on record. Learned advocate.
The father was a traffic constable.
Was a traffic constable.
Calcutta. On 22nd June 2013, he died in harness, leaving behind the widow and the only daughter.
Daughter.
Sorry, the widow and the son.
Son. Yes.
At the time when the father died. Widow was offered appointment. She intended that someone in the family should get appointment for running the family. Widow was called upon as to whether she is interested to take the duty. At the time of looking at the widow mallet, the officers mallet advised her that you are so weak and old. Better you should wait till your son reaches the age of 18. In the meantime, because there is a provision, the rules, 5 years relaxation is given in case visible person is not available in the family of the deceased.
EMT 25.
Not, yes, 26, it is given, 26. Yes, 104. 3. Kindly come to 3.
Yes, EMP 26. Sorry, not 25.
Now the form page AA, page 104.
That is with two qualifications, if we remember correctly. One is death must be in action, and second is there must not be any other qualified person. Only if the
all the two criteria, my lord. One criteria, my lord, the person, no eligible person is there. First of all, and secondly, there is no other.
So where have you stated that the mother was not eligible?
Other
Let us see from your way.
whole case, my lord.
Yes.
The
Come to the OA, please. Where is this averment that the mother was not qualified?
Why he was offered the appointment, she made a representation. Page 60.
60.
Was called upon at page 59, my lord. Oh, sorry, my lord. I'm extremely sorry.
Please be kind to me, sir.
The part of the petition in the tribunal, without that, my lord, I cannot.
At least whichever document you want to rely, give me a translated copy. You get it translated outside the court, you give them a copy. If there is no dispute about the
She said that I am so weak, I cannot carry on any work. Therefore, kindly arrange for my appointment of my only son who is there.
We don't know. We'll see what she has said. We don't know what she has said. The point is whether she is qualified or not. if she is qualified, whether EMP 26 allows her to forego in favor of someone and invoke 10AA or not, that is what has to be seen.
She is eligible or not. She was found to be not eligible by the police officers.
Qualified or not. Read what it says in 10AA.
What eligibility has been, my lord, there in the notification? Page 10.
Yes, eligible means having the basic eligibility.
Therefore, you are physically found eligible to discharge the work of a group D staff of a police.
She could have got herself scrutinized and medical board could have assessed that she is not eligible.
That was the advice given by the appointing authority in course of the index. In the appointing, that appointment has not been denied in the opposition before the trial. The appointing authority offered it.
All right. So therefore, the
February, it was my case.
so what is her infirmity? What does she say? If what his lordship is saying that she has said that she is suffering from some physical.
Certificate is there, mother. Medical infirmity certificate.
Where is that?
It's also part of the.
It is enclosed with this application.
The application has been accepted by me.
You mean accepted? Anyone who applies, they will accept. The point is whether it is allowed or not. That is all the.
Fail the test.
Maybe.
Interview.
If
Thereafter said you are out of time. Whether I am out of time or not, that is the only issue.
That's the only issue, whether you can get benefit of 26 EMP or not. If you cannot get the benefit of 26 EMP.
26 EMP provided you are within time of 5 years. I shall be giving you the lordship calculation that he came before 5 years.
No, 5 years is not the only thing.
Other parameters.
5 years is not the.
Other parameters they did not. That was that own case. I have made out in my petition that you are unfit physically. You cannot discharge the work of a group D staff of a police department.
See, we have seen enough cases by now. Appointment under exempted category is one thing. And for those who do not fulfill the physical requirement, they are allowed to get appointment in the other departments. So therefore, there is not the scheme is not so watertight that if you cannot get exempted, then you cannot get.
I was not found to be eligible on that day.
Because exempted category, you may not be. It's a very common thing. We have seen in so many cases. There are some people who are not coming up to the physical requirement. Then they don't get appointment on exempted category, but they get compassionate appointment in the other departments. So that you can't say that you are not eligible for that. You are eligible for that. So if
because of my physical infirmity, I could not.
Yes, we have understood. Exempted category, maybe you cannot, in view of the doctor's advice, maybe that would not have been permitted. But you should have applied for any other appointment. There is we will ask them, they will say, but there is a provision that those who cannot get a exempted category, they will be appointed. Where is that?
Your Lordship, that is not even the case here. Your Lordship, may I please? 2013, the employee expired. The petitioner hearing, the widowed wife applied for his son. His son was not eligible. The authorities advised that the son is not eligible. Thereafter, immediately within time, she applied for her appointment. Your Lordship will kindly come to their petition itself, page 59. Your Lordship, in 2014, her application was forwarded. Page 59, 4th October 2016. She was directed, if you are willing to be appointed, so please call at the establishment section on such and such date with such documents, Your Lordship. Your Lordship, there is no document in the OA or in the petition indicating that the authorities has rejected her application on the ground of health or said that she is not eligible for the post, Your Lordship. It was only in 2017-18 she withdraws her application saying that I am not well. So now in 2018, from 2018, my son will be eligible. Kindly give appointment to my son. Which is 13, 14, 15, 16, 17 and 18 year olds. 5 year already gone. That 5 year limitation also doesn't apply.
So when does he attain the majority?
Lordship, in 2018.
What is the date?
I died 22nd of June 2013. I attained the majority
September 2018.
February 2018.
What date? February?
The year 2000, I was born, my lord, date of birth. I was born in the year 2000. February.
He was 13 years, 3 months and 7 days.
What is the date? What is the date?
The date of birth is 16th of February 2000.
So 16 to 18 he has attained majority.
But the last date is June 2000.
16 to 18, yes.
Date of birth, date of death of my father.
22/6/13.
Plus 5 is 18.
Correct. So we are saying that it is within 5 years.
Your Lordship, she applied for
Yes, we have.
appointment. We had called her for with all the documents for appointment, asking her if she is willing. In 2016 itself.
You have filed a reply before the tribunal.
Yes, Your Lordship.
Where is that? Where is that? Show us
Yes, Your Lordship.
your reply before the tribunal.
Page 73.
Your Lordship, paragraph 4, page 75, the relevant portion. Has been stated that the petitioner, the wife of the deceased, was eligible at the time of the death of the petitioner. System.
That application that he was referring to, have you said anything about that application? Wherein she has stated about her physical inability? This annexure E, have you said anything about annexure? This annexure E is referred to in which paragraph of the OA?
Kindly, my lord, come to page 34 of my original way, paragraph 6 by 6, not replied at all. That was my whole case. Paragraph 6, Roman 6.
Your Lordship, 6 is denied and
Only
it has been stated that clause 10AA does not apply in this case.
did not deal with.
It does not apply.
And where is that provision? If that one is not eligible in under the exempted category, then
Your Lordship, in that case, Your Lordship, in exempted category, that is the qualification. Group D. Your Lordship, that is there in the 2013 regulation, Your Lordship.
please show us where it is.
If there is a relaxation of educational qualification may be granted eligible for the case of appointment in Group D. For there, your lordship, educational qualification has been relaxed. If they are not, they don't have the regular.
In some case, in one case, I recall that we have seen that provision that the family members or dependents of a police personnel, if he does not fulfill the requirement for appointment under exempted category, he may be considered like a regular aspirant for a compassionate appointment.
The
Where is that?
one regulation which says appointment of compassionate ground or to the Group C post should be made only on probation or existing and Group D post on regular basis, and this is only after vacancy is meant for an exempted category available. The appointment authority will have the right Group C or Group D post, even if the dependent.
Which page you are reading?
This is page 95. An appointing authority will have the right to appoint a dependent either to a for a post, even if the dependent is qualified for Group C post. Your Lordship, I presume this is not the.
This is 2013
Yes, Your Lordship.
notification.
And Your Lordship, in this case.
So in one case, Mr. Mukherjee had shown us.
I shall verify. Your Lordship, in this case, Your Lordship, the only one document which was perhaps not clear before the tribunal. Your Lordship, in this case, where the petitioner, Manav Mondol, had appeared for examination on for appointment on regular basis. Once he failed to secure an appointment, thereafter in 2018, he wrote a representation to the authorities seeking compassionate appointment. Your Lordship, that has been annexed at page 14. Sorry, Your Lordship, page 17. But the difficulty is there is no translation, Your Lordship. I shall produce a translation on the next day, where he admits that he had appeared for exam, he has failed.
No, but the scheme does not say that if a beneficiary for compassionate appointment has tried his merit, then he will.
Absolutely, Your Lordship.
Then he will be.
In this case, Your Lordship, the wife was eligible and admitted.
So therefore, because she has submitted a medical certification, which is also issued by the medical college and hospital, then
After Your Lordship, 1 year, Your Lordship, the offer was given to her in October 2016. She did not take any steps.
so this is after 1 year.
Yes, Your Lordship. In 2017, she comes up and withdraws the application, saying, "Give me appointment for my son."
Appointment.
Your Lordship will kindly see
Let
that
us
document
show the
59.
offer of appointment. The offer of appointment, no, this is an on.
Your Lordship, she should have taken steps if she was interested.
So this offer is also not for the police service.
No, Your Lordship.
This is for Health and Family Welfare Department.
Yes, Your Lordship. She was aware for Group D post, Your Lordship.
Yes. This is not for police service.
For Group D post with compassionate appointment, according to her qualification and eligibility. But she did not respond to the same.
Yeah, means to get an settlement.
Have the translated copies before we.
Your Lordship, one thing, Your Lordship, kindly see page 61. The doctor's certificate they are relying on, though it is dated 22nd September 2017, it has been attested on 15th February 2018, Your Lordship, and submitted. Your Lordship, immediately before, soon before the petitioner was due to attain the age of majority, Your Lordship.
Rejection
Your
of
Lordship, from 16,
2022.
the wife had left the letter unresponded,
Rejection of son's
despite being eligible.
rejection of son's application was made in 2022.
And Your Lordship, there is no document to show that we had rejected the wife's candidature on being physically incapacitated or physically ineligible.
Was not counted 5 years, but his entire other parameters have not been considered.
Submissions to the
On record. Yes, it's not from the part.
absolutely, Your Lordship. 10 AA does not apply to them because his wife was eligible.
That is the
And she had applied.
That is the issue.
She had applied.
You have accepted by son's application. That is.
Your Lordship, acceptance and consideration of an application doesn't accrue rights.
Sixty-nine is the son's rejection.
Yes, Your
And before the tribunal, the son was the applicant.
Son and mother both were.
Both were applicant.
They are also.
Here also, both are.
So give us the translated copy. The learned advocates have advanced.
Seven.
But in 11, my lord, yesterday I have mentioned this matter, my lord, before this honorable court has risen, my lord.
Before?
For rising of this honorable.
Yes.
Lord, Mr. Shandip Rai's father has passed away, my lord, on Saturday. So he went to Benares.
2 weeks. On grounds of bereavement.
First September.
September.
First September.
First, 1 তারিখ।
Well, I appear for the petitioner, my lord. That this matter relates to the
Land user
land
matter,
user
my
matter seeking employment, my lord, under the railways. The issue of
Now we have been adjourning all the matters because they have challenged some of the orders which you will be relying upon. When we have adjourned those matters to ask. What?
আমারও হয়েছিল সব একসাথে।
When it was adjourned?
Perhaps in the September.
No, those orders must have been. Every case they say order not up.
On 7th,
7th,
আমি মনে হচ্ছে 7 তারিখ।
yes. The
My lord, 19 also.
call the next.
20 is the same matter. Same.
13, item 13.
Lordship kindly, Lordship order on 15th of May 2015, kindly.
We wanted you to tell us whether this issue has been considered earlier in any case. You said I will examine. But how long we will keep it pending? Then let us decide. If you can't say, then we will decide the issue. It must have fallen for consideration in some case.
That matter, my lord, the petitioner would not file the pro forma application instead of pro forma application.
And
It took place on
Mother applied in kind.
10.
and submission of prescribed application 28 December 2012.
Mother, my lord, applied in
Submission of a pro forma application in 2012 by the wife.
Paragraph 10A of 2016.
No, who made the application on plain paper? On plain paper.
for his son.
Plain paper.
The application was filed in kind.
No, this is 2013 circular has not been modified. Only certain clarification is made in 2016. But 2013 is not going to change.
Yes. Here the flight. Same thing.
After the date of the Lord, they did not came into the house of the petitioner, not advising. 20 page, my lord. Earlier matter was hard. Your lordship already got it.
Under 2013 circular, paragraph 10.
We'll see.
Item number 4.
This is the matter for a long time we are arguing. There was a point on limit.
You were not there, therefore we
Sorry, my lord, so far the limitation point is concerned, there was a question, there was a bar of section 21. But your lordship was of the opinion whether we could get a chance to the learned tribunal to convince them on the question of limitation. Lordship, that these are the copies of the reply, certified copy of the reply we have obtained. So far, we have given the reply to the 10 objections, position, we have given it. But so far the limitation is concerned, this appears that it was submitted after the reply was given. Now, Lordship, this will appear from this record. This is the reply filed on behalf of the respondent number 1 and 2. Reply was affirmed on 18th August 2017, to which we have given to respond, and reply on behalf of the respondent number 1, 2 was affirmed on 23rd June 2016. But these were the only reply which were filed. Way 1300 was filed by one special revenue officer of the respondent number 1 and 2. She filed the reply on 23rd March 2008. An application rejoinder to the reply filed, it would be found from the next application. Applicants rejoinder to reply filed by the respondent number 1 and 2. This was affirmed on 23rd June 2008. It's two reply. Apart from that, not find anything. So far, where reply is concerned, it paragraph number 3. Applicant filed this instant application approximately 2.5 years after receiving the rejection order. I am unable to calculate the extent of delay period as the copy served upon the respondents is incomplete because it does not contain the date of verification. As per section 21 of the Administrative Tribunal Act 1985, the application has to be filed within 1 year from the date of receipt of the order, which is to be under challenge. But the applicant has neither be accepted the delay nor advanced any reason whatsoever for the said delay seeking condonation of the same. Rather, on the contrary, he submits that he prefers this application within the limitation period so prescribed under section 21 of the Act of 1985. The entire statement is false. The instant application is liable to be dismissed. Now, this was affirmed on 18/8/2017. Now, applicants rejoinder to the reply filed by the respondent number 1 and 2 was affirmed on 23rd June 2018. Now, these two documents which we have obtained, my lord, I place it as it is. Say that 2023/6/2018 and (2017). This was the rejoinder which was the opposition which was filed on behalf of 1 and So these are the queries of your lordship. I obtained them. Right.
So there was no application for condonation.
There was no application for condonation of delay. This is the affidavit.
Plus whatever you have stated in your rejoinder in para 11, that hardly improves the situation, because in 15 you have already filed an OA. So that also is not sustainable. You are saying you have given to the lawyer, he said he will take care, he passed away, but you had already filed in 15 and that you have withdrawn. And 15 application, what had you challenged?
It was way 970.
Of 2015, yes.
Short code, which is in paragraph 31. An order to issue upon the respondent authorities to direct them to issue an appointment letter in favor of the applicant against any suitable job on the basis of the report of the inquiry committee in the regular establishment as died in harness category, so that the legal heirs of the deceased may not.
From where you are getting this?
My lord, in the application, that is way 970. Lordship, this can be found from our application page number 20. This supplementary affidavit page number 20. Sorry, my lord. Supplementary affidavit page number 20. And my second prayer was an order to issue upon the respondent authorities to set aside and quash and cancel or withdraw the impugned memo number 863 dated 19/2/2014 issued by respondent number 3 addressed to the respondent number 4, whereby the prayer of the applicant may not be considered for employment assistance on compassionate ground immediately, so that the legal heirs of the deceased may not suffer.
So both the OAs were filed for the same relief.
Simultaneous, together, both of them were on board. One was withdrawn.
Yes, the earlier one you had filed, you withdrew it. And the subsequent one you are allowed to continue, but with a rider that issue of maintainability will remain open. Still, you did not file any application for condonation, knowing that the issue of maintainability is open. And 1 year was the limitation. And there is no averment why you filed 2 applications. On that, there is nothing.
Just this position I cannot include.
We just wanted to clarify, because only for the delay we did not want, but it appears that date of death is 5/12/11, and on that day your age was
Below 18. Now the reason they are saying, Your Lordship, if I am able to cross this hurdle, then I have a very good case, my lord. But whether the age can be considered on the basis of the date of application or date of decision.
perhaps within a fortnight.
No, not here is question is how section 21 could be overcome. No, 2004. 2014.
Yes. And so far, Lordship, the recent judgment of the Honorable Supreme Court of Justice Dotto, I have already relied on that. It also talks about the proximity, the certain factors which has to be considered apart from these aspects while considering the application for delay. However, in my application, my lord, I cannot improve the position because I did not file the condemnation of delay at all. Yes, ma'am.
But that also it totally ignores the filing of the earlier OA. Currently, he has got caught.
And transfer has been injected.
Where is that withdrawal order?
Well, this is the order dated 12/5/2017. 12/5/2017, which is already submitted. May I hand over a copy of it?
File is not there. Second file, where is the second file?
12 May 2017. 12 May.
12 May 2017. Well, may I hand over a copy?
And where is the 2014 order? Rejection order.
Order is in page 20, my lord, of the petition, P5. Order dated
19 February.
29.
Which page, please?
Page 20. My lord, prayer for no.
19 to 2014.
The rejection is on
19 to 29/4/14.
yes, ma'am.
19 to 2014.
It is communicated on 29/4
29
at the bottom.
April to the communication.
Hard learned advocate.